All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Parme, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for the first segment of our Strategic Advocacy Across Courts, Agencies, and the Legislature CLE series. This segment is called Nexus of Administrative, Legislative, and Litigation Advocacy. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you registered, you're going to receive a copy of the recording and the materials via email from Zoom within about 24 hours. If you didn't register, no worries because we're going to be posting it on YouTube as well. On the YouTube description, you're going to find the link to the materials as well. I will also post the CLE code in the YouTube description in the chat, and it will also go out in the email that goes out from Zoom. And speaking of CLE, this segment was approved by the Florida Bar for one general CLE credit, one state and federal government and admin practice certification credit, zero point 0.5 professionalism credit, zero point 0.5 ethics credit. So Viletta, we did it. We got like credits for everything. See, thank you for all your help with this. And closed captions are enabled for anybody who needs them. If you're having any issues with the captions, just let me know and on the chat or via email, and I'll make sure that those are working for you. This training is being co-hosted by the Admin Law section of the Florida Bar and the Public Interest Law section of the Florida Bar. So now that I think of it, we have Pills and Owls. Are we pals? Is that like our merger, Violetta? That's a great name for this. So
I love
it's
it.
pals. So I'm going to drop information for both of the sections into the chat, including their websites, social media links. So make sure to bookmark those websites. Check if you're not a member, check out the membership benefits as well, and follow us on social media, both Pills and the Admin Law section. So I'm gonna drop all of that information in the chat. For questions, we're gonna ask you to hold your questions towards the end. We have some time set aside for questions towards the end, so you're going to be able to use the Q&A feature. So if for whatever reason you have questions that we don't have time to address during today's webinar, you can email me and I'll make sure that our speakers receive those questions and we'll try to get an answer for you. So, and before I pass it over to our speakers and introduce them, we have three speakers today. So you might want to look at your Zoom settings and maybe you want to switch them to gallery if you want to be able to see all of our speakers at the same time. But otherwise, Zoom might show you whoever is speaking at the moment. So without further ado, I want to do a quick introduction of our speakers. I do have like the full-length bios and the materials if you want to check those out, but I'm just going to go ahead and quickly introduce our speakers. Our first speaker is Dr. Amy Wetherby. Dr. Wetherby is a distinguished research professor at Florida State University's College of Medicine and founder and longtime director and the former director of the Autism Institute. With more than 45 years of experience, she is a nationally recognized leader in early autism detection and intervention, co-developer of Autism Navigator, and principal investigator on multiple federally funded research projects focused on improving outcomes for young children with autism and their families. Our next speaker is Robert Jurand. Robert is a retired attorney with more than 30 years of experience at Florida State University, where he focused on administrative, higher education, and healthcare law, and served as chief legal counsel for the College of Medicine. Earlier in his career, he worked as a prosecutor and an assistant state attorney in Tennessee and Florida. And our last speaker, and thank you, Viletta, for organizing this amazing series. Our last speaker is Viletta Coombs. Viletta is a Florida bar attorney with more than 20 years of experience in administrative, legislative, and litigation advocacy. She has dedicated much of her career to public interest work with Florida Legal Services and multiple Florida state agencies, focusing on serving vulnerable children and families. Ms. Coombs is also an experienced trainer, presenter, and leadership development professional. So without further ado, Violetta, I'm going to pass it over to you. The floor is yours.
Thank you so much, Jorge. I appreciate it. And thank you to Amy and Rob for being here with me. This is an awesome reunion, and I'm going to begin strategic advocacy across courts, agencies, and the legislature. Again, presenters are myself, Viletta Coombs, Robert Jurand, and Dr. Amy Wetherby. Before we begin, I need to provide this disclaimer. The content of the CLE, as well as the views and opinions expressed by the CLE presenters, do not reflect the views of current nor former employers, including but not limited to Florida State University and the Florida Bar. The presenters' views are their own and not legal advice. The presentation of this information does not form an attorney-client relationship. This information is for educational purposes only. Segment 1, the Advocacy Nexus. Strategic Framework Overview. Clients come to you with problems, not solutions. Given your area of general practice or expertise, you may narrow the scope of your review of the matter. In your review, consider the nexus of administrative, legislative, and litigation advocacy via the following process. Identify the issue. Second, develop the legal strategy using administrative, legislative, or litigation advocacy or a combination thereof. If needed, identify the perfect client to pursue the issue. Impact. The outcome impacts all people or entities with that issue. Use this framework to evaluate the following case study. The Strategic Advocacy Case Study. The following case study is based on factual events between 2010 and 2011 involving Robert Jurand as counsel for Florida State University, Dr. Amy Wetherby, the executive director of the Center for Autism and Related Disabilities within the Florida University system, and myself, Viletta Coombs, attorney and parent. For the purposes of the case study, this incident takes place in Marshland, a fictitious state that follows the laws of Florida and mirrors Florida's system of government, executive, legislative, and judicial. In 2010, Mrs. Magpie gets a call from the executive director, who's the ED, of the Center for Autism and Related Disabilities in Marshland University, MarshU. And CARDS. CARDS provides support and services for children that are diagnosed with autism and related disorders. Autism spectrum disorder is a neurological and developmental disorder that affects people and how they communicate, interact with others, learn, and behave. The ED knows Mrs. Magpie, an attorney, and asks Mrs. Magpie for help. Mrs. Magpie explains that she cannot talk to the ED as an attorney because the ED is represented by counsel from MarshU. Mrs. Magpie explains that she can talk to the ED as a parent and client of CARD. All 7 CARDs have received the same public records request for the CARD newsletter mailing list, which includes personally identifying information about clients of CARD, their parents, and their addresses. At this time, there's no public records exemption under Chapter 119 Florida statutes. The ED of CARD, Mrs. Magpie, and counsel for MarshU are in a bind. So the question becomes, how do they protect this information? And here I'd like to hear from Dr. Amy Wetherby about if you could explain a bit about the problem and how this came to you when you were out of the country.
Yes. So I was traveling in Africa doing research on early features of autism across cultures. And I received a call about this public records request that had come in under Chapter 119 in the Florida statutes, and was asked to provide the records, which included the CARD client mailing list, to the university so they could respond to this record request. Now, my concern was that this list includes identifying information such as the name and address of the clients, but also by nature of being a CARD client, the requirement is that you have to have a diagnosis of autism. So it implies and reveals their diagnosis along with this identifying information. Of course, with children, it would be the parents' information as well as the children's information. So I requested that nothing be released and to please hold off on any action until I return to the United States, keeping in mind this was a while ago. Communication was not as good as it is now across countries. And so I really asked them, I think I was going to return in 3 or 4 days. to at least give me that time. But that did take a little extra time and added a little bit of complications. But time for me to think. I also asked the other 6 card executive directors, EDs, to not provide any records. So just hold on, hold off. And when I got back, I was going to try to explore other options.
Thank you. And Rob, if you could explain the position with the Marshland University's General Counsel's Office.
Sure. Well, as you know, universities being state agencies subject to Chapter 119, the public records laws of Florida, um, the university is obligated to release records upon request, so long as they're not exempt or confidential. And as you alluded earlier, there was no public records exemption for these requested records. So we started looking. Obviously, we searched all the statutes and regulations, and so far we're not able to find anything. And obviously, the university, when there is no exemption, has to provide these records, or there are substantial sanctions in the statutes for failure to provide those public records. Also, we got an indication from the executive director, Dr. Wetherby, that she was not inclined to release these records. So it did put us in a kind of an unusual situation as to what to do next. But obviously, the university, as a state agency, wants to comply with the law and also avoid any sanctions that might arise from refusal to comply.
Absolutely. And I think also one of the things that happened is with Dr. Wetherby's stance of the refusal to release the records, the general counsel of the general counsel's office made it known that if she did not release the records, then the general counsel's office would not represent her. And this leads us to this poll that we're going to ask. And I didn't preload the poll into the Zoom. So, and we're so crunched for time because we have a lot of information to cover. We're going to ask the following questions. If you want to respond in the chat, I think you can. But for poll A, if you're the counsel for Marsh U, who is your client? The ED of CARD, Marshland University, the Board of Trustees of Marshland University, or answers 1 and 2. So we're going to give you just a little bit and see what you put in the chat, 1, 2, 3, or 4. Okay, we've got a variation of responses here. They're coming. All right, we've had some, okay, more coming. Okay. Well, while you all are continuing to chime in, I want Rob to actually answer this question and explain to us who the client is.
Sure. Well, that question actually comes up a lot, believe it or not. I saw a lot of folks who were answering number 2, Marshland University. And in a sense, that's correct, but a more correct answer would be 3, Board of Trustees of Marshland University. The reason for that is because a university has no legal status. It doesn't really exist. It only as a legal entity that can sue or be sued and contract and so on. The only I would say entity that is so established is the Board of Trustees of the university, and they can contract, be sued and sue, and otherwise have a legal status. So the correct question, the correct answer to that question would be 3, Board of Trustees of Marshland University. adding to that, I would just say that it would also include some of the executive members of the administration when acting on behalf of the Board of Trustees of the university.
And I think this does come up a lot, especially if you're with a state agency and there's a problem that's happening, and sometimes it involves an employee. And so sometimes you're in defense of the employee, right? But if the employee isn't in line with what the agency is asking them to do, then they're no longer a part of your client space. And so that question is a very real question of like, who is your duty to? Who are you working for, and exactly how are you supposed to frame your position, and that determines how you proceed. So let's go to poll B. If you're counsel for Marsh U, to whom is your ethical duty? The ED of card. Number 2, clients and parents of card. Number 3, Marshland University. Number 4, all 3. So if you'll answer in the chat. Okay, while folks are answering, I'll go ahead and ask Rob to respond to poll B.
Sure. We saw a lot of folks giving number 4 as the answer, and I'll have to say that's the correct answer, because as counsel in the state of Florida or in Marshland, you do have an ethical duty to perform your legal duties in an ethical manner. And whether it's to the executive director of CARD or the clients and parents of CARD or Marshland University, you have a duty to proceed in an ethical manner to all 3. And this question is different than who is the client. This is a general question in terms of professional responsibility that we have an ethical obligation to everyone we come in contact with in the course of our profession.
Absolutely. And also, who's not listed is the person that's the requester of the public records, right? We also have an ethical duty to that person, just in the sense that we have an ethical duty in how we perform our jobs as members of the bar. And so now I'd like to move on to our next set of talking points with Dr. Wetherby and myself. So you're in a bind here. If you don't want to release the information, but you're being told if you don't have representation. If you could speak about these talking points.
Yeah, and so there are 7 cards in the state, and we're in statute, and so we then are awarded as through grants to each of the 7 universities. And there's a question, I just went ahead and wove that in to answer that was a good question. And so I talked with the other EDs when I got back, and we were all mortified. We just assumed that our records were sealed and that we wouldn't release them. We definitely informed our clients of that. When they joined, we had paperwork that said we will protect the confidentiality of records. We reached out to legislative aides and legislators to just, aren't we exempt? No, to find out no. We assumed we would be covered under HIPAA or FERPA, the medical and educational laws that would protect confidentiality, and then found out, no, we're not. We don't really fit. We don't qualify. So I was devastated, and I felt my obligation was to protect our families, our children, our constituents. And so I conveyed to our general counsel that I will not release the records under any circumstance, and that I would be willing to go to jail if that is what it would have to come to. That I felt so strongly, there's no way I can do this. And I was the keeper of the records, which helped a little bit. I had control of the database, although of course they could probably get IT to find it. But okay. And that's when I then
Understood.
reached out to you in your
Yeah,
role as
me.
Mrs. Mack.
Yes,
Hi.
right. Just me. In my role in terms of Marshland as Mrs. Magpie, and I expressed my concern as a parent, of a client of card. It's terrifying to think about, Mandy Magpie's information being released, and the fact that she does have this condition of autism. And so I'm trying to walk this line of the fact that I am an attorney, but I'm also a parent, but I can only speak from a parent perspective. And I realize it's really difficult to have that conversation about how to protect this information. So I asked Dr. Wetherby, asked the ED if she could set up a meeting with she and I and counsel for Marsh U. And so when we have our meeting, I ask Rob if I could have permission just to speak freely about the law in his presence, with his clients, and talk about our concerns about getting, having this personally identifying information released. And we can't understand how there's not an exemption under Chapter 119. We all agree there should be an exemption, but it's just not there. So this is 2010 in real life, and there's no exemption.
Yeah.
Let's look at the law versus legislative intent. Clients of card and their parents do not have a public records exemption under Chapter 119 Florida statutes, and no one understands how this could happen. It seems like an oversight and inconsistent with legislative intent. For example, identifying information about children and parents in government-sponsored recreation programs is exempt under Section 119.0715C. So why is personally identifiable information exempt in this instance, but not in our instance? And so let's take a look at that statute. 119.0715C. So for the purposes of this paragraph, you get the definition of child, but let's look at sub B, government-sponsored recreation. Let me go back to A. Let's just go through it. Child means any person younger than 18 years of age. That's the criteria. You just have to be younger than 18 years of age. In a government-sponsored recreation program means a program for which an agency assumes responsibility for a child participating in that program, including but not limited to after-school programs, athletic programs, nature programs, summer camps, and other recreational programs. And so information that would identify or locate a child who participates in a government-sponsored recreation program is exempt under 119.07 and then Article 1 of the state constitution. But let's go back to 3. Information that would identify or locate a parent or guardian of a child who participates in a government-sponsored recreation program is exempt under 119.07 and also Article 1 of the state constitution. But 4 is the best for me. This exemption applies to records held before, on, or after the effective date of this exemption. This is important because this is saying that this is retroactive. We're covering all time. If they participated before, they do it now or in the future. These records are exempt. And the only qualifying factor was that you were a child under 18. So if you have an exemption for them, how could you not have an exemption for this vulnerable population of children that have disabilities that impact their ability to communicate? This is real and very terrifying. I'm sorry. So During the discussion, we realized that we don't have anything to stand on, and I'm concerned that the counsel's office is taking the position at MarshU, taking the position of you just need to release the records. But I don't think they understand what's at stake here. We're not talking about widgets. We're not talking about an inanimate object. We're talking about people that belong to a very vulnerable population. We're talking about children. And I'm concerned that there are people in the general counsel's office that don't even know what autism is. And so they're standing by making decisions about something that they don't know nor understand. So they're making what I would call an uninformed decision. And so, Rob, if you could pick up here in the talking points, page 6.
Sure. Yeah, sure. Absolutely. Well, um, so, well, I just want to say that there were 7 card centers, and we spent a lot of time meeting with counsel for the other card centers or universities. And just to tie on to Dr. Wetherby's comment earlier, the legislature established the card centers by statute to be associated with the colleges of medicine of the state universities, and so that's how they became part of the state university system. So, in talking with counsel for the other universities, we could not come up with any kind of exemption in searching the statutes. It wasn't HIPAA. It wasn't considered medical services. It wasn't considered FERPA information. And obviously, this was a glaring oversight. I think from a historical standpoint, there may have been an assumption that because these card centers were set up within colleges of medicine, that somehow that medical moniker would have provided some sort of exemption, and just wasn't really fully thought out. So, um, from my standpoint, I had a boss, the general counsel, who was obviously juggling a lot of issues. And just when I discussed this, it was pointed out that, look, we need to just comply with the law and move on. But I was very concerned, obviously, that the clients of the card center would have some of their records released and identified. And so it was very, very concerning. And I did meet up with you, as you recall, uh, and Dr. Wetherby to discuss what we could do about that. Um, we also didn't know what the intent was
Mhm.
for this request, and we cannot uh, always ascertain what someone is trying to get information for, or what the purpose is. Oftentimes, it's pretty clear what an intent of the request is. In this case, we weren't sure what who was behind this and so on. So it kind of put us in an unusual situation in that we had a client, or rather a representative of the card center, who was obviously part of our client, that was refusing to release these records. Um, you know, and so it put us in a bit of a bind.
Dr. Weatherby?
Yeah, and I just want to add, thinking back at that time, which still exists to a certain extent now, the stigma of autism was very negative, and a lot of parents didn't want that out there. It also could impact it. They may not want it in the child's medical record because certain insurance companies, if they have the diagnosis in the medical record, then the child may not qualify for insurance. Now, some of that has changed. It's been a long time, but back then, not the case. So the child may not be covered with that diagnosis. And then in school, the parents often didn't want the teacher to know the diagnosis or other students. So getting the diagnosis was a very difficult thing, and still is, for families to get it and understand what it means and the implications of it. And so we wanted to protect. CARD is this agency that has our own records and had the ability, we thought, to protect it. And certainly the legislatures assumed, as much as we did, that this information was protected. So we all messed up. We all did not, think about this. And the other big reason for exemptions at universities is research. So if a child is in research, then they're exempt. However, CARD stipulates that you can't use CARD funds for research. So it's a service program, not research. So that didn't cover us either. So it was a very difficult, but I held very strong that this is the wrong thing to do. I will not do it. And I had to really help my other EDs to hold on, and let's try to come up with a better solution.
Yeah, this was a serious problem, and there's absolutely nothing you can do because the law says no.
Yeah.
So what do you do when the law is the problem? So, yeah, did I go up too far?
Let's see.
So yeah, there was an assumption. Yeah, I think I went up too far, but there was an assumption that the legislator would not want to have identifying information, such as the name and address about children with developmental disabilities and their parents to be released as a matter of public record. So as the discussion continues, it's clear that the information is not protected by HIPAA because CARD is not a medical facility nor providing having medical providers. And although CARD had in some way was also housed under the Florida Department of Education, the identifying information isn't protected under FERPA because it's not an educational institution providing educational services. And these were different types of services. And so we start to realize there's absolutely no protection. So it becomes clear the only way to protect this personally identifying information is with a legislative fix. CARD needs to seek a legislative exemption under Chapter 119 Florida statutes. So while this is true, there's still an issue of timing because the public records request is waiting. In real time, it's waiting. And the legislature will not move within the next 30 days. So someone needs to respond to the public records request. The ED of CARD contacts the person that made the public records request, and the ED refuses to release the records and explains why releasing personally identifying information about children with autism and their parents compromises the health and safety of these clients. So upon hearing this, the person that made the request acknowledges the concern and discloses that they want the mailing list to advertise their products, services for children with autism. And the ED informs the requester that their products, services can be advertised in the newsletter, and the requester can get a booth at the annual convention in Marshland. Dr. Wetherby. Go ahead. You saved the day. Go ahead.
Yeah, and I guess I'm not a lawyer. I clearly wasn't going to allow the law to dictate what I was going to do. I just kept feeling like, let's talk and figure out a solution. So if the request for the exemption wasn't going to happen fast enough, then the only other thing we could come up with is let's reach out to the person who made the request and see if they'll reconsider. I didn't even think about whether I could do this or not. I just did it. It seemed like the logical thing to do and something that might help resolve the problem. And so amazingly, it did. And so after reaching out and then trying to get everybody to listen to each other, right? Because the council were pressuring us, the EDs, to release the records, and I'm pressuring the other EDs who I have no real power over, right? Please don't release them. Please give me a little more time to find a solution. And I just felt like there's no way this is the right thing to do. And once you release the records, they're out there forever. You can't take it back. And this is so serious. Surely we must be able to get someone, like in the legislature or somewhere, to be able to do something. If we can't do the exemption, let's do something. So the easy thing was talking with the person who put in the request and I didn't even think about limits on what I could or couldn't say because I'm not a lawyer, and I just reached out to them. And I obviously use common sense and knowledge that I have as a professor of many years. And so we had a very civil discussion, and this person had no idea that this was going to violate the confidentiality of the families. And so they were very willing. What became clear is they were very reasonable and willing. And I was then able to say, well, if what you want is to be able to share information with parents of children with autism, about your, it's like for marketing of their products and services, I can help you with that. So we have a statewide annual conference. I said you can have a booth at no charge to there, and I offered some other ways to get information out in general in our newsletter, that we could put the information in the newsletter but not release the client confidential information. And he was actually very pleased to do that. And so he revoked, what's the right word? He rescinded his records request. And thus it was solved. From my perspective, it was solved in the moment, of
Yeah,
course.
right. In the moment, and that piece of it was solved, but the bigger problem was still looming for all of us, and the fact that there just was no exemption. But I want to point out and circle back to, this is about the power of a conversation.
Yeah.
You know, everyone, again, from the general counsel's offices, remember, every university that has a card has its own general counsel. So within all those general counsel's offices, again, they were talking about something that they didn't necessarily understand. Many of them didn't even know what autism is. They didn't know what it is. They didn't understand the gravity of what was at stake if this list is released. And what happened is, when Dr. Wetherby talked to the requester saying, hey, I'm not going to give this to you, and here's why, that person was informed and educated. They didn't understand the gravity of the request and what would happen if the list was released. And so many times when people are at odds or they have an opposition, they don't use it as an opportunity to educate. It's an opportunity to educate. It's an opportunity to talk to someone and not just at them. There's also education included in your advocacy. And so, Rob, if you could talk about a takeaway with respect to the public records request from the university or state agency standpoint here.
Sure. Well, we field a lot of requests. It's a large entity, and 5,000 plus employees. We get a lot of public records requests from all over the place. You can't always understand the intent, and you really can't ask for why someone is requesting the records, because well, put it this way, you can't make that a condition of complying with the request. You can ask if it helps you provide the records. And occasionally, I've contacted a requesting party just to make sure we understood fully what it was they were requesting. The law doesn't require them to put it in writing, but I often would, if we're having a decent discussion and you can see that they're actually interested in getting the records and they don't have some other unknown purpose behind their request, we will let them know that this allows the records, which may be in a lot of different places within the agency, a written request allows the different people who may have these records understand exactly what is being requested. So occasionally I will have contacted someone to ask that they clarify their request, put it in writing. Oftentimes it does come in writing, but it's not required. The statute doesn't require that a public records request be put in writing. You could just pick up the phone and ask for records, and that's all you have to do. And we do often understand you can tell from the request what it is they're looking for. Sometimes we even get requests from opposing counsel ahead of discovery, which is particularly tedious and annoying. But I just tell the client at that point, look, you're going to have to provide these records in discovery anyway, so go ahead and start gathering. But fortunately, that's not the case that often. So anyway, that right there reflects the power of conversation with someone who's making the request. It's not you can't condition the response on their answer, and they don't have to tell you. They don't even have to cooperate. I'd hate to think what would have happened if in this particular case, the requester just refused to respond to Dr. Wetherby's offer to place this in the newsletter, or if this was somebody that was requesting this ahead of some potential litigation that was upcoming. So fortunately, that was not the case, and this was a really fortunate kind of heaven sent sort of result in this matter.
And I want to kind of dovetail with you on what would have happened if they didn't accept that. Because the university's position at Marsh U, their position was release the records or we're not going to represent you. And unfortunately, there wasn't a discussion about trying to take steps to protect the records. And so from a parent standpoint, and I'm an attorney, I was going to figure this out. With or without Marsh U, I was going to figure this out. We're both attorneys, my husband and I. We were going to figure this out. But what we'd be left with is if they were going to go ahead and release it, then someone's going to have to try to file an injunction, right? And try to stop this while this gets sorted out at the root, which is going to be that legislative process. But it's absolutely terrifying because while all of this is playing out in real time and quite frankly, quickly, as it's playing out, there are all of the parents and children under CARD, because CARD actually serves infant through elderly, but for the purposes of our exercise, we're focusing on children. They don't know this is happening. They just would have found out after the fact. Wow. And that would have just been absolutely heartbreaking. Go ahead, Dr. Wetherby.
I think I would have informed them before that, to be honest. Mm-hmm. And I didn't understand why the general counsel wouldn't discuss figuring out a way to file an injunction. So that was the part that, why can't we pause this so we can figure out a solution? There was this pressure to respond quickly. And I know they had been fined in the past or something had happened in the past. They get these records requests all the time. And if they don't respond in a timely fashion, they get fined and, it gets complicated. So I understood the legal ramifications for them, but it just seemed like logic should bear some way to pause this. And someone, a judge or a legislator, should be able to make that happen so that we have time.
Yeah.
But luckily this solution came along fairly quickly.
And it bought some time because it wasn't something that we necessarily wanted to advertise, but I want to keep us going right now and talk about the advocacy strategy. So you identify the issue. The issue is identifying information about clients of CARD and their parents is a matter of public record. You're going to develop your legal strategy using administrative, legislative, or litigation advocacy, or a combination. So develop a campaign for a legislative amendment to include a public records exemption for clients of CARD and their parents. That's your only clear path right now. That's it. And it's a lot, but you have to think about what's at stake. 3, if needed, identify the perfect client to pursue the issue. Well, this issue impacts all clients of CARDs. All 7 CARDs and their parents. And then the 4th part is the impact. The outcome impacts all people or entities with that issue. So this impacts all people with the same issue. This is what you would call systemic advocacy. So we have a crisis, and our crisis is averted. Okay. To effectuate a much needed change, lobbyists affiliated with CARD and Marshland universities campaign for a public records exemption for clients of CARD and their parents. And that's the bill. And it becomes effective on July 1, 2011. The 2011 update added a subdivision 6. This is a section that did not exist in the 2010 statute. And so under the statute 104.556A, client records, all records that relate to a client of a regional autism center who receives the services of a center or participates in center activities, and all records that relate to the client's family are confidential and exempt from 119.07 sub 1 and then Article 1 of the state constitution. I can't express enough what was at stake here, and how, with the information that came from the meeting that Dr. Wetherby and I and Rob Jurand had, that's the thing that changed everything, this meeting, because now everyone with this clear mind and pathway went to their respective corners and started actually working together. This would not have happened if you didn't get the buy-in eventually from the general counsel's office. This would not have happened. You had to get the buy-in. Secondly, once they have, come on board with wanting to protect this information, now that they understand the gravity of what's at stake here, they actually dispatch their lobbyists, because they have them, to go over to the legislature and push through with this campaign. The pushback didn't really exist within the legislature because they understood what was at stake. They thought it was covered too. Everyone assumed that the exemption existed, and why wouldn't it? When you think about the exemptions that do exist under 119, this falls perfectly within that realm. And when I'm looking at this and I'm looking at the law as a barrier, I immediately go to legislative intent. It couldn't possibly be the intent of the Marshland legislature to release this type of information. It's just not consistent with the laws that we have. So this crisis is averted because no one looked at the law as a barrier. The law was the answer. So often folks see the law as a limit when they really need to seek a legislative remedy, if you need it. And I mean, the stakes are high as they were here, because you're essentially, with the release of that list, publishing a victim map. That's what you're publishing, is a victim map with specificity. Change the law. You don't have another choice. And the general counsel's office could have taken the position of, we didn't write the law, not our problem. But if it's at your front door, don't ignore it. The stakes are too high. You have to do something about it. This crisis was averted because Mrs. Magpie, the ED of CARD, and counsel from Marsh U had a conversation that culminated in a meeting of minds. This was an exercise in the power of talking to someone instead of talking at them. When's the last time you went to your opposing counsel or your opposition and said, how can I help? What do you need? What are your goals? Try to problem solve it. Just listen and talk to them. Don't talk at them. It does change everything. This crisis was averted because the ED of CARD had a conversation with the opposition and helped the opposition meet their goal without compromising the health and safety of clients of CARD and their parents. This crisis was averted because a successful legislative campaign was launched to protect the health and safety of this vulnerable population of children and their parents. Now is a good time for us to go and have Q&A. We are on schedule, guys. Giving you a nice 10 minutes here for Q&A. And I really hope that I really hope that this is helpful because it sounds so simple to say, hey, have a conversation, but this would have fallen apart if we didn't have that first conversation, all three of us.
First of all, Violetta, this was amazing. I loved like how all of you presented this as a story. Like I was like, do I need to get popcorn for this? I didn't cheat and I didn't look at the slides ahead of time, so I really didn't know the outcome. So it was kind of great to see it develop. We do have one question in the Q&A. This was asked about like
Okay.
5 minutes ago. I'm not sure exactly what slide it was in, but the question reads, we may need some clarification, but the question is, from a strategic standpoint, why did you decide to specify? So I'm not
Can
sure
you
what specific.
from can you tell us, can you rephrase the question
Yeah, that's what I
possibly?
probably need from the person that asked the question to clarify because I'm not sure what they're referring to
Mhm,
with what you wanted to specify.
mhm.
Let's see.
Yeah, it's an anonymous attendee, so
Yeah, so I don't know who asked it. And I know we have a lot of the of legal aid people in the audience, and
yeah.
there's one of the slides that kind of hits home, which is the strategic advocacy slide, and there's specifically bullet points 3 and 4 where it mentions that perfect client. And you know,
Yeah.
a lot of the legal aids have some legislative restrictions. They can't lobby, but once they have that one client, you know, it opens the door for a lot of possibilities. And I
It,
was mentioning to Robert early on when we joined that you know how we at legal aid sometimes have really limited resources. We have to be creative, and this is why
Mhm.
I kind of love this
yeah.
story because you know by helping out one client you can really have an impact on a lot
Yeah.
of people.
So
So
the
I
anonymous attendee did resubmit the question with more detail. You want to read that, Jorge?
Yeah, here it is. So from a strategic standpoint, why did you decide to specify autism in the legislative advocacy instead of a broader protection for folks with neurodevelopment disorders?
This is a really good question. Um, what what happened in real life is that the card center got the request, and I think at this point, everyone's trying to put out a fire because this house is burning down.
Yeah.
And I think what can happen from this, when you look at legislative intent, is you can take the exemption for card centers and the other 119 exemption just for children under 18. In other words,
Yeah.
the legislature has an interest in protecting this information as not being public record. You can take the groundwork that was done with this statute and use it to push for a broader exemption is what I'm saying. This is your tool because that's what you can do when you find that, hey, we actually need this over here, we need this over here.
Yeah.
Go and pull these statutes like this one and go to the legislature and say, I'm looking at your legislative intent. It seems clear that this is a vulnerable population that we want to protect. And right now, we don't have this protection here. Can you do what you did over here? Will you expand it?
And also keep
Go
in
ahead.
mind, CARD serves from infants to seniors, citizens, adults way beyond school age, way beyond 18 years. So this exemption was specific for CARD and covered CARD clients and the age range, and that did have to have the diagnosis or diagnostic information to support this diagnosis. But I do think it would be great to think about a way to do developmental delays or neurodevelopmental disorders or both broadly in an exemption as
And
well.
yet,
But that might be limited to 18 and younger or 21 or younger. I don't know. But if there are adults with cognitive delays, maybe they would be included as well.
I say use
Autism,
it to push for
yeah,
it.
yeah,
You use it, you can use this to push for it for a broader impact.
yeah.
I see
Like,
a question of what if the opposition had a negative intent and wanted the victimless, would the injunction process have worked? Um, that would be up to the judge who makes that decision, but that would be my next legal pathway to fight it. And it really, I think, should come from Marshland U in terms of the injunction. Um, but that would be the path to fight it, and it's up to the judge, and you can just appeal it and keep appealing it and appeal it. But guess what? Not everybody has a parent who's an attorney um, that has this issue. Um, this was kind of a perfect storm in terms of the card center reaching out to me. Um, and me being an attorney and having a perspective of saying we need to talk to your general counsel and find out how we're going to solve this. So
But
so
my
that
sense
was
is our general counsel would not have done the injunction, but I wasn't going to stop there. So was definitely, and Rob was a sort of mediator for me and the general counsel, and that I think Rob had a very important role because the general counsel really didn't have very many discussions with me, and Rob did. And so I don't think we would have stopped, but I don't know how we would have solved it. Um, and so I'm grateful that it worked out. But I don't think that the university was going to request the injunction.
That they may not have. Um, my experience is that um, you know, probably not. But I don't see why parents
Mhm.
uh, eh, couldn't get together and step in
Yeah,
uh, and get it done that way.
yeah,
And the university certainly wouldn't oppose
yeah,
that, obviously.
right.
But it might have had to have been one or more of the parents that kind of stepped in and did that in conjunction and with the support of Card.
and
And it,
that's just the thing. I'm an attorney, so I know, but if it had been another parent, they wouldn't necessarily know. So it
right.
it turned out to be the perfect kind of the perfect storm where the right people were in the right place. And thankfully, all three of us were talking to each
Yeah.
other,
I
you
know
know.
we were talking about having parents go to the Board of Trustees. So that's
Mhm.
one thing. And I have had to do that on other issues. So I think that letting a bigger group of parents know and then thinking about what are things that the parents could do to help trigger the possibility of different solutions.
Do we have any other questions that we might be able to answer here?
Don't see any pending questions. We still have a few minutes. I do see some positive comments in the chat. Thank you for the great presentation. I did take the opportunity to drop the CLE code in the chat. I'm going to read it out loud. The CLE code is 2600938N as in Nancy. This code is going to go out via email. You will see it in the YouTube description as well. And just in case, I'm going to drop the link to the materials again, just in case. In the materials, you will find a flyer that has the links for all the upcoming webinars, all the upcoming segments for this series. You see, the next one is next Tuesday on the 10th at noon. So we see it here on the screen. And the flyer, you will be able to scan the QR code or click on the link to register. I will also try to make it as easy as possible and send all the registration links via email. It might be a lot, but I will drop them in the chat here as well. We've been posting these on social media, so if you follow the admin law section and the pills section, both on LinkedIn and on Instagram and on Facebook, we're posting those on social media as well. So let's see if we have
Before we
any
go,
other.
I just want to give a special thank you again to Amy and Rob for coming together on this. You may see a statute, but you don't always know the backstory of how that statute came to be. And this is where it all started because we came together. This is happened in 2010, 2011. So we're, over 15 years later, and it's a really wonderful reunion. And I thank you guys so much for working with me and coming and co-presenting. And special thank you to the Public Interest Law Section of the Florida Bar, the Administrative Law Section of the Florida Bar for co-sponsoring this, and also the Florida Legal Services Statewide Training Initiative. Thank you all.
And thank you, Viletta. You
Thank
were a
you.
great leader.
Thank you very much.
Yeah.
All right. Well, I guess that's a great way to wrap this one up. Thank you, everybody that joined us today. Thank you to our speakers. This was an amazing session, and I'm already looking forward to the next one next week. So have a great rest of your day, everybody. Thank
Thanks
you.
to everyone.
Thank you.